All right, ebusuya ya mamu na makwa abasonko so eba Ghana Politics 7 AGH Politics 7 ahana open all the trending political stories in Ghana osa betumi akan na ebusuya na story de bremu edamu sonko ensembe na ye de bre sum yetifo ne yahwefo USP ene Attorney General ho sensem na ye de bedum na ensembe na eboboba. Fast forward nani dedi kan ba channel so ada o mani de no gbo kwan so be subscribe to channel no o subscribe we have notification bell na o do nsa bo se be ya video we ni video afro bia de ba do mu bia no nsa betumi aka bi na so otimi hu de ekoso Ghana ya manyo semu ni ya kabi mami kabi amamu ni na ebusuan OSP ni Attorney General sensembe private citizen bi na assume Attorney General court se Ghana mra enche se Attorney General ma OSP kwan so on prosecute amanfo na so onfa amanfo nkogina asem dibia court na we na OSP su koyi na no court free etunisa free OSP ekoyi na no ana OSP court tunisa free Attorney General rather yes because nipa ne ebo Attorney General ko edu se oni kwan onaso oni tumi se opoma ni tumi ni bi na ne powers ni bi ma OSP so do bo amanfo ko edu etiwe na court tunisa free Attorney General akoyi na no na Attorney General ekoyi na no nsembe na Attorney General di tuju Attorney General se ono de oma akwan bia se OSP mbo amanfo kwadu ewo nu dim na ono de OSP ye na dwuma no so ye na dwuma onim de OSP onim hwe ana de Attorney General so yim hwe ono kra de ka no kwa nka OSP office nka yentwem na yentete emfiri wo na ono onya kwan ye na dwuma sansemi gbogboba Attorney General de sa anu yi koma court na I bring up a big reaction will be a channel will be a chess na se media enye true hash enye true ena man for church o madwe na mumye konyenko TV Oliver Baka bomo de se me true dawo joy news for adwumadi su chirechire mu yi ema obi ati ne was me nko Oliver Baka bomo e ba de obi a de my Ghana police 7 me nko Oliver bless ya.
Let me just preface this by saying that because I'm involved in conversations around the potential amicus before the court, I'll be more descriptive about the impact rather than the legality or otherwise. Because, and again, just for viewers, I'm not checking out because the Supreme Court or courts have generally been saying that an amicus must be an disinterested party.
Yeah.
And so I just want to be clear on that. I think that the issue that Bobby is raising, surprisingly, goes again to the root of the decision before the court. And I'm talking about whether or not the OSP can intervene. Because when you look at Article 88, there are two things there. Mm-hmm. It is about the civil authority and the criminal authority. Mm-hmm. When it comes to the civil authority, the courts have been able to fashion out some exceptions which have allowed statutory bodies, for instance, to be able to maintain actions in their own name and can be sued in their own name, irrespective of what the phrasing used in Article 88, which is that the Attorney General is responsible for all civil cases. What we haven't seen is the court go into the direction of how the criminal provisions ought to be interpreted and whether or not there's room to create some window or margins around it in circumstances like this. So the resolution of the criminal part might reflect how we have dealt with the civil question, or it might take a different approach. We don't know that for certain. But for me, the most important thing here, and when the Attorney General's file...
Please explain to my audience.
Yes.
You are saying that the power given to the Attorney General under Article 88
yes.
to be responsible for both criminal and civil,
yes.
the courts have innovated to allow that the civil power,
yes.
that one, entities and individuals, even though in working for the state,
yes.
can maintain their own lawyers
yes.
and do their own work.
Yes.
But the criminal side,
we haven't touched it at all.
Okay.
So when you look at how both are phrased, they are phrased almost in a similar fashion, which is here. Now, on the question of the Attorney General's filing, in this case, for me, the biggest and most fundamental issue here is that the Attorney General has said, I have not given a fiat to the OSP. So that those who are defending, because when you look at the defense and the opposers, they seem to be agreed on the same thing. Those who are defending the OSP seem to suggest that, no, in fact, we haven't taken away the Attorney General's discretion here. The Attorney General can continue to license you to do it. None of them is asserting that the OSP can independently maintain prosecutions without the Attorney General. And so when you look at Bobby's rationale and thinking, he's saying that the phrases like subject to and other things still continue to preserve the Attorney General's oversight over the OSP. And those who are doing the otherwise also agree that the oversight is necessary, except deny that it has in fact been preserved. Now, the Attorney General has said in the filing before the Supreme Court that they have not given a fiat to the OSP. Then it means that even for the defenders of the OSP's office in connection with the law, a critical step has been missed, which means that all the OSP's prosecutions become immediately vulnerable.
Yeah.
Unless the Supreme Court finds a way to create an exception. Because if your maintenance is that the OSP continues to depend on the office, and the office AG, and the AG says, I haven't given that fiat, then it means that the fiat must evolve. You must stick with the position that Parliament is competent to delegate the fiat to the OSP without the AG's intervention. Okay? So if that's the hill you're going on, then you must die on that hill. So for me, policy-wise, we must be sure of the broader policy implications of the direction in which we are going. Now, the Attorney General's office is a policy office and not a litigator, in my opinion. And so that, as a Minister of State, you must be mindful about the logical extension of the positions you take, generally, and its effects on broader government policy and government positioning on the fight against corruption. So therefore, if you come into this conversation and treating it as if it is a Sabbath Hall, whatever legal committee argument, then you might miss the broader policy implications of what you're arguing and the position you have taken. Because on the one hand, we are maintaining, based on investigations and work prepared and filings made by the same OSP to seek the extradition of Oforiatta into the country. And then we have said that the person lacks fiat to do any of these things. Where is the policy consistency then in the legal argumentation that we are making?
What is the Oforiatta angle you brought in? Because
the OSP who is lacking fiat is the one in court in connection with Oforiatta. And as far processes which, per the Attorney General's reckoning, he lacks mandate to do. And you have used that same process that he has filed in court to request an extradition.
To the Justice Department.
To the Justice Department of the DOJ. So that for me is the natural implication of what has been put before us.
If I get you, additionally, or among other things, the extradition request is in jeopardy.
No, it's not. I think that to the extent that the OSP that has initiated the process does not have the power to be able to initiate it in court, it could be. But you can still divide it up, because you consider the extradition packet and request is not dependent on the prosecution in court, but in the fact that we're investigating a crime. And in that regard, with respect to the mutual legal assistance, the OSP's, the AG's office is the nominated body that can make a request. You can bifurcate that. But it means that the prosecution, underlying prosecution itself in the court, it itself is in jeopardy.
Okay, so I'm thinking like a lawyer now. If I had a client who is being pursued by the OSP, by now I'll be filing applications.
Oh, absolutely. And I've said this.
That I'll say that the OSP doesn't have power.
I think that automatically, to be professional incompetence, not to immediately go and file a referral and join the matter. Because it is in doubt. But
and if I were lawyers for Ken Oforiatta,
I think they would raise it.
A bigger part of my argument why the extradition should not happen,
I think they would raise it.
Will be to use this argument by the Attorney General.
I think they would raise it.
In the US.
I think they would raise it.
They will.
But I mean, I think that as a lawyer, if I was involved in any of these proceedings, I think it would be professional incompetence not to immediately hop on it. But let me be clear though, that one of the things I have done, because when I immediately read that in Attorney General, I then started making calls to determine whether or not a fiat does not exist. Because I have questions, I mean, like every lawyer has continued to debate on this issue of the constitutionality of the office for so long, that I have called in the past to ask whether or not a fiat exists as a saving mechanism. So that when law fails, we say, well, the fiat exists in any event. And my understanding was that the fiat did exist. And now the AG says that the fiat doesn't exist. Some have suggested to me, and I haven't seen it still, that Dami had given the OSP, the SP, a fiat. I still haven't seen it. We've not been able to procure it from the Assembly Press. So I don't know for certain whether one exists. And this is something in which I do think that some amount of clarity will come on. So for me, my interest is in that bit, the fiat bit, and not the bigger constitutional issue. Because in any event, we are in a process of constitutional reform. And that the uncertainties around delegation of prosecutorial authority and its bifurcation or multiplication is now being proposed to be restructured by this Anti-Corruption and Ethics Commission that the Prepare Committee has advanced and put forward, which we are waiting on the Attorney General or the government's position paper on the way forward on these issues. So that might give us a sense of clarity as to how we want to reorganize prosecutorial power in the Republic, more generally. So I do hope, and I do, because I am not able to this point determine with conceptual clarity the NDC's position as a whole. I know that some people within Parliament attempted to introduce a private member's bill, and then it was disavowed as a mercenary project and doesn't represent the party. The presidency spoke against it. Now the the Attorney General has taken a particular position. And let me be clear. The power in Article 88 does not belong to the president. It belongs exclusively to the Attorney General. So it is possible that the Attorney General and the presidency will hold different positions on this.
So should the president be speaking?
On this particular matter?
Yes.
I mean, I think
so that we know where he stands.
As a general politician, he can express his political views. The extent to which he has control over the Attorney General in connection with Article 88, I am of the opinion that he doesn't. And this is important to me to say because the reason why we found ourselves in creating an SP office should not have arisen if the Attorney General understood that that role was not subject to executive direction and control, and that you could prosecute whoever. Now you can exercise that power without the presidency interfering in that. And I want to continue to maintain that view of that role that Article 88 has conferred to the Attorney General as an independent constitutional officer. And in fact, it is the only minister that the Constitution creates.
The Attorney General, by Clause 1 of Article 88, shall be a minister of state and the principal legal advisor to the government.
Yeah.
The government is an executive presidency.
Yeah.
So the president can direct the Attorney General and directs the Attorney General.
I don't.
What is this suggestion about independence of the executive?
The two things. One, this is the only office which the Constitution designates and makes a minister of state.
Correct.
For which reason, no president can come in and say they will not. You're already imposed on you by default. Your role then as an advisor to the government in how the government conducts its business has no bearing on when you are making prosecutorial decisions. In
who is the head of the government?
Oh, the executive. You're advising the government. You see, there are different roles that the Attorney General occupies within this. It's a minister of state. He advises the government. It's the principal legal advisor to the government by the Constitution. But it's also the one who initiates all civil actions, and it's the one who initiates all prosecutorial actions. All are distinct heads of authority. That's in terms of how I view it. Now, it doesn't mean that in your independence, if the executive was to procure and ask you for advice, that's your constitutional role. The question is whether or not you are subject to the president's direction in the performance of your prosecutorial functions. I don't believe you are.
If you are an advisor, my advisor, I don't see how what you're talking about works.
That's in theory. He's talking theory.
No.
You are a constitutional office. The Constitution says, I have the power to appoint you.
Yes.
And when I appoint you, you are supposed to advise me. We can't have different views.
It goes.
We can't have different views on the matter.
It goes on.
We can't have different views on the matter as this, where the president says, stop your attempts to collapse the office. And then the Attorney General is doing the same thing.
But look at this. Look at what happened in the US, for instance, with Nixon. So many times that the President Nixon tried to instruct the prosecutors in connection with Watergate, all of them resigned. That we are not subject to your direction in terms of the role that we have to perform. Now, you may say, like he said, that is a theoretical view of the office. But I think that it is intended to be able to procure some element of independence. And that is why that particular thing was not vested holistically in the presidency. That whoever he designates, and we don't prosecute in the name of the president.
Right.
So
if I was the OSP, I would file another application to join.
They filed, then they were thrown out.
But it's an interlocutory.
The Attorney General was in court represented by Justice Sai, and he said that we are the ones to defend them, so don't let them come in. And the Supreme Court stopped them.
That is what I'm saying, that if I was the OSP, I'll file another application.
With this new development.
With this new development, because the first ruling is an interlocutory one. When the circumstances change, you are allowed to. Because I think there was a case involving the Speaker of Parliament, where the former Attorney General raised that same issue, that he's a member of government, so the Attorney General. Yeah. And the Supreme Court said, because your interest is not aligned with his, he's entitled to have an independent...
That was not the first. The first was Domolevo.
Well, exactly.
The Attorney General wanted to represent Domolevo, and they said, no.
So if now...
The Attorney General was in that case, and then
and
also...
he was also in the Speaker. So if now the circumstances, the facts show clearly that the AG is not defending your interest, then I think they should apply for another, because the facts have now changed.
The suit is a constitutional challenge.
Yes.
It is not about the occupant of the office. It is about how Parliament, they challenge that Parliament did something wrong. Who is the defendant in that? Is it not the Attorney General?
Yeah. But the same way in the suit involving the Speaker of Parliament, it also involved constitutional interpretation. And it was the Attorney General. But because the Speaker of Parliament would be affected, or that office, they allowed him access to an independent, or should I say an independent, a separate lawyer. So for me, since now it is obvious that the Attorney General aligns with that of the plaintiff, then it means that it is fair that the OSP be heard. If not him, like-minded persons can find amicus, can file amicus to defend on that side. So I think the OSP should reapply.
I see that the CSOs that filed the suit in the Domolevo case and who have also been filing cases in other cases, they are putting themselves together.
I think that there's enough precedent from the Supreme Court's own previous...
But what is this suggesting that if the SP or a different view does not come, the court will grant what the plaintiff and the Attorney General agree?
It is not, because the Supreme Court have always maintained that even in the absence of an opposition, they have the jurisdiction to ascertain the merits of the case. But like
the same with all the courts.
Yes, but like they say in G, so under these circumstances, it may be in the best interest of the Supreme Court to allow the office that will be directly affected by the outcome of the decision to make submissions about it. Because the law was not just passed. It went through a lot of representation. In fact, the title of the law states clearly under the authority of the Attorney General.
The long title, yeah.
The long title. It states very clear that under the authority of the Attorney General. I think the issue has been in practice whether before they do any prosecution, they should actually go to the Attorney General for authorization. And I think that is where, because for me, I don't see that the law itself breaches the Constitution, because the law acknowledged that Article 83 must be there. 83 must be there. That is why the long title states clearly that it should be under the authority of the Attorney General. And so if there's contrary position by the office holder now, I think it's only fair that he be heard. So if I were him, I would apply again for the joinder, because the earlier ruling doesn't create res judicata because it's interlocutory. And then once the facts are now different, and it's very obvious the Attorney General aligns, and he has contrary opinion.
Alright, ebusunya da mu nyina masese mo jebre na mo de tie na dan da ni na ye di videos bre mo amotoko so ehwe na mo di akiri emaye said the aye no higher Ghana Politics Avenue open all the trending podcast stories in Ghana dia aye na onsa bekam nen de kan ba channel yi so ani de no bo kon se be subscribe to channel ya AGH Politics Avenue channel be subscribe na afi notification bell no adoma no no don sa bo se be ya video any video of bi aye de ba bedum bi an onsa betumi akabi no hu de ekoso Ghana ya manyo semu ani akabi mami kebi amamu afin so uwia video da bedum woni ji na wa like ni wa share ama afoforo so de enya bi wodofu bi unuya wadamfu bi no onu so nya bi ahwe no so ntumi hu de ekoso Ghana ya manyo semu ni akabi mami kebi amamu ni afi uwia comment section won so inja wakwa mi hu adwenche efa video da bedum ni esu encheche ya adwen wo ho na in our own small we nesu ntimi nya di bitima ye aboa ama Ghana ya manyo semu ni akabi mami kebi no etumpo na akosa da mu na masama de bre na mu de tie said that then na high Ghana Politics Avenue open the trending podcast stories in Ghana ya na unsa be kan da mu na masama de bre na mu de tie na mu da hwe ya kra mu na nyaminka mu bye bye.